Good afternoon, everybody, and welcome to the fourth in Fenwick Elliott's series of lunchtime webinars. I'm Tony Francis, one of the senior partners at Fenwick Elliott, and I'll be chairing this webinar, which is all about on-demand bonds, performance guarantees, and some things to think about given COVID-19. I'm joined by one of my partners at Fenwick Elliott, Claire King. Claire specialises in construction and energy law, and Claire has acted for a number of clients in a number of matters involving various issues to arise from various forms of bonds and guarantees. I'm pleased to say we're also joined by Anneliese of Fountain Chambers. Anneliese is one of the leading silks at the Construction and Commercial Bar, with a particular interest in performance bonds. Of note, Anneliese acted for the successful claimant in the Court of Appeal case of Nidco v Santander, a case where we were also instructed, and Claire worked very closely with Anneliese. Anneliese will be covering that case later. Before we start, just a few housekeeping points. During the webinar, all your mics will be turned off. However, at the end, there should be an opportunity for some questions. And during the course of the webinar, if you use your toolbar at the right-hand side of your screen, you should be able to submit questions. I'll endeavour to put as many of these as possible to Claire and Anneliese. Hopefully you'll find today's session informative. Over to you, Anneliese.
Thank you very much, Tony. Well, in these COVID times, we want to talk about something that even in normal times can provoke fear in the mind of a main contractor's commercial manager when you receive a threat of an employer's demand on a performance bond. And what Claire and I are going to do is try and go through the basics and distill it down and hopefully give you some practical guidance, both when you're negotiating these instruments at the beginning of a project and then throughout, or if they're called upon or you want to call on them, the things to look out for. Now, I wanted to start by just looking at and reminding ourselves of what performance bonds are. They're instruments that are typically provided by a bank or a financial institution, and they allow the employer to make a claim against that bank or financial institution up to the limit of the bond, which is often 10 to 20% of the contract price of the works. As performance bonds require bond issuers, in older cases often called bondsmen, to make payment in the contractor's stead, performance bonds are commonly referred to loosely as guarantees, often referred to as performance guarantees. And that's because whatever kind of performance bond is being issued, the bond issuer will be making a payment in place of the contractor and might be said to be guaranteeing their performance. Now, in the diagram you can see on the slides, what I've set out is just to show the typical contractual relationships between the employer, often called the beneficiary under the bond, the bank, the guarantor under the bond, and the contractor, often referred to as the principal. And the basic point that flows from that diagram that's important is that the contractor or the principal is not typically a party to the performance bond between the employer and the bank. So under a typical performance bond, neither the employer nor the bank will owe the contractor any contractual duties. Now, there are two main forms of bonds, what are called true guarantees and on-demand guarantees. And because the use of the word guarantees can be quite confusing, Claire and I are going to call them on-demand bonds and contingent guarantees. But you will also see the phrase demand guarantees used. So try not to get too confused. There's a very recent and helpful summary of the distinctions between these two types of bonds by Mr. Justice Fraser in the Uganda case. And Claire is going to talk a bit more about that in detail later on. But he set out the distinction between the two. And just to go through it very briefly, If we look first at what are called true guarantees, contingent guarantees, because these have been around for a lot longer. They've been around for about 200 years. And there are two legally important features of a true guarantee. The first is that the guarantor under a guarantee is not liable unless and until the principal, i.e. the contractor, has failed to perform. And in order to recover under the guarantee, you will have to show that, which obviously can be a slow and costly process. In addition, a true guarantor has a range of potentially available equitable defences, which are set out in no less than 40 pages in one of the textbooks we used, Chitty on Contracts, and are surprisingly easy to engage. So the process of proving the liability of a principal under a true guarantee could take many years. Demand guarantees or on-demand bonds are a much newer instrument. They've been around since about 1978, and they have become very popular and a common and very frequent feature in the majority of large construction projects across the world. And what they do is they provide that the bank has no right to make an inquiry into the rights and obligations of the contractor and the beneficiary under their underlying contract. So the core feature of an on-demand bond is that the bank must make payment against a beneficiary's demand that complies with the documentary requirements of the guarantee. And that's a very important feature of on-demand bonds that's been repeatedly underlined by the Court of Appeal ever since they came into effect. And I've set out there the Edward Owen case. You will see that when a demand is made, the banks are bound to pay. The banks will rarely, if ever, be in a position to know whether that demand is honest or not. And the bank must pay according to its guarantee on demand, so the clue's in the name, if so stipulated, without proof or conditions. The only exception is where there is a clear fraud of which the bank has notice. So you can see how hard that test is to meet, and I'll explore that in a little bit more detail later on. This has been reiterated time and time again by the courts. So this is just another example of a case saying that once you present documents, you're entitled to call on the bond. There's no inquiry into the actual facts. And indeed, the only exception is what's called established or obvious fraud. So this really is, we talk about smash and grab in adjudication, but performance bonds really are smash and grab. Now, one of the things that causes difficulty, and I'm very proud in COVID times to have found a case that involves Wuhan, but one of the things that causes great difficulty is what type of instrument do you have? And obviously, as I've outlined, it's very important, what can be very important, what type of instrument you have. And as it turns out, the leading case on this is a case called Wuhan and Emporiki Bank. And if you ever have to determine this, it's a very useful starting point to look at. The Court of Appeal, when they considered this, were concerned that they had to consider around 20 authorities to try and work out what type of instrument this was. And the judge described this process as exhausting. And one thing when you're drafting these instruments is to make sure that you can fall into difficulties when you have a mix and match approach to drafting. So do try and be careful when you're drafting them to ensure that you end up with what you want or what you think you have. And there were a number of things set out in Wuhan which were said to potentially give rise to an instrument being an on-demand bond. So the first thing was whether there's some standard wording that is incorporated by the URDG. If that is found to be in an instrument, then it is likely to be an on-demand bond, likely to be determinative. Second, have you got a conclusive evidence clause? And by that I mean a clause saying that the demand, the amount set out in the demand will be due and payable, save for manifest error, be conclusive and binding. Again, if you have that, it's likely to be very important. Sorry. In a recent case, the third one you see there, it was held that if the guarantor wasn't a financial institution, then that meant it couldn't be an on-demand bond. Fourth, if there's any wording suggesting the bank's liability is not secondary, but again, you need to look at all the wording. Fifth, no exclusion of guarantors' equitable defences. And then finally, there's a slightly odd one about the parties being in different jurisdictions, but that is something that in more recent times has said to be not so important. So assume that you have an on-demand bond and you want to make a call on it. The first thing is that you must comply with the formal requirements. There has been some debate in the cases about whether this is absolutely essential for performance bonds. If you have a letter of credit, it is undoubtedly essential. But my advice would be to make sure that you do comply. There's at least one English case, the one I've put on the slide here, Sea Cargo Skips, that sets out that if you don't comply, you won't be able to enforce your instrument. And you will see that under that instrument, what was required was a statement saying that delivery of a vessel had been delayed by more than 270 days, according to Article 4E of the contract. And when the notice was served, the statement was served saying that delivery of the vessel had been delayed by more than 270 days. What they didn't do was to expressly refer to Article 4E in that statement. And because of that, it was found that they couldn't call under the bond. So that shows quite how strict it can be. And it is a reason why it may be prudent, at the risk of sounding like a turkey voting for Christmas, to consult lawyers to ensure that any documents that are being served do comply. And there's someone who's obviously got it wrong. So I want then just to look in my remaining time at the fraud exception and what other defences might be raised, because once you've made a compliant demand, the prima facie rule is it has to be paid out under the bond. So the guarantor's only defence to payment against a formally valid demand is one of fraud. And it's important to remember that that will require you to prove fraud to a high standard. And this is the NIDCO case that Tony mentioned earlier that Claire and I appeared in. And in that case, we were calling on the bond. It was actually a letter of credit, but that doesn't matter for these purposes. It's the same principle. We went not only at first instance, but to the Court of Appeal. And the Court of Appeal were very, very clear that the banks would have to show that at trial, and these are the words used, the only realistic inference is that there had been fraud. And you can see quite how high and how difficult that test will be to meet. So you need to catch somebody in the act. It's been suggested that you need extraordinary facts. Having said that, there are two cases in the TCC where fraud has been found. One of them is on the slide, the Tetronics case, and the other one is a case called HLC. It's interesting that it's in the TCC that this exception has been met. My experience of being in the commercial court is it's almost impossible unless you have documents that show that fraud has been committed. So where your claim is being heard may make a difference. And what you need are documents to show fraud, and you need to be able to show fraud without having any cross-examination. Now, in both the cases that I've mentioned in the TCC where fraud or a seriously arguable case of fraud was found, the extraordinary facts needed was that in the first one, there had actually been a written note saying that the contractor believed that the subcontractor was not in default. but then they proceeded to make the demands anyway. So you need very strong and very cogent evidence. In Singapore, there has been developed something called unconscionability. It's important to note that that will not apply in England. It's also important to note that even in Singapore, the courts have rowed back a bit from unconscionability because it can be difficult to say what is unconscionable, whereas of course fraud is an easier test to prove. Now, what if you're a contractor and you want to stop a demand being made on an on-demand bond? You can apply for an injunction restraining the demand. There are only two grounds on which that can be done. First, that the demand was made fraudulently, and secondly, that the bank was aware of the fraud. And in reality, I suggest that is going to be very, very difficult to show. And I have set out there, Tetronics again, the contractor had sent a legal opinion to the bank in advance of the demand, stating there was no ground for the demand. And there were other facts in that case, but they were unusual. And so just to reiterate, it will be difficult to prove. It's worth having a look to see what the correspondence says, but simply because you disagree about a view that's been taken is not enough. Perhaps a more useful ground for restraining a demand on the bond is that the demand would be in breach of the underlying contract between the principal and the beneficiary. And this is something that arises out of a Court of Appeal case that you'll see in the second box on the slide, Sirius. In that case, the parties had contractually agreed that the letter of credit wouldn't be drawn down on unless two conditions were met. And the Court of Appeal found that an injunction in those circumstances could have been granted to restrain the demand. And what has then happened is in the TCC, we've had 4 decisions where injunctions have been sought. In the first and the last one, Anneliese and MW High Tech, injunctions were refused. And the judges in those cases said that the evidence must positively establish that the demand would not comply with the agreed contractual mechanism. Being seriously arguable was not enough. And in MW High Tech, in the middle two, which were dealt with by different judges in the TCC, a realistic prospect or a strong case was found to be sufficient. And in my view, there must be real doubt that those middle two cases are correct. The Court of Appeal has never ruled on this issue. And so it's important to be aware of the fact that there is some dispute as to precisely what tests apply, and it may depend on what judge you get. So it's something to look at, but it's also something to be aware of it not being entirely clear in relation to what the position will be. And now I'm going to hand over to Claire, who's going to tell you a little bit about guarantees.
Thank you very much, Anneliese. So in this section of the talk, I'm going to focus on things to think about for guarantees in light of COVID-19, I mean contingent guarantees. So a lot of you may have seen this headline in the Construction Acquirer about a month ago. And I think it's relevant, first of all, to think about the impact of COVID-19 on performance guarantees that we're trying to obtain at the moment for new contracts that are being negotiated or entered into. This is obviously a headline warning that people are finding it hard to get performance bonds. By that they mean guarantees. So I thought it'd be helpful. I spoke to a couple of entities who provide these sort of securities yesterday, so sort of they say about what's behind the headline from their point of view. What they wanted to emphasise very much is they are open for business as usual. They viewed this headline as sensationalist, but having said that, in terms of COVID-19, they are, even with their established clients, getting much more stringent on the financial vetting that they're doing for their clients. So, for example, before they may ask for quarterly management accounts, Now they're asking for monthly updates on the accounts and cash flow. They're also issuing specific COVID-19 questionnaires, and questions put in those include what are you doing to protect your cash flow, and what sort of provisions are you including in your new contracts to try and protect yourself from, for example, if there's another lockdown for COVID-19. They also said that if they make an offer of a bond on at a certain price, that offer may not be open for as long as it would normally be. So 30 days, for example, it may only be open for, because they're obviously anticipating the market may move, the price may change if events change on the ground in relation to COVID-19. So, alternatives to guarantees. Obviously, the price you are going to pay to obtain security, to obtain a guarantee, is going to vary depending on your financial strength. And as the impact of COVID-19 perhaps gets worse, that may put the price of these securities up. Obviously, ultimately, the employer is going to be the person paying the additional costs of obtaining these. So people may start to think, or have to start to think, about alternatives if costs get too high. And these are just some examples of things people may want to think about in their contracts. So longer payment terms, perhaps, to give the employer more comfort that they're not going to be they're going to be less out of pocket if somebody goes under in between milestones. Larger retentions again, so they've got more money held back just in case. And amended termination provisions. There's always you can't terminate for insolvency until somebody is actually insolvent. And there's sometimes a lead up to that where people sort of know what's happening, things are going slowly on the site, and but you can't terminate yet. You have, under the JCT clause contract, you can start issuing notices for failure to proceed regularly and diligently, but there's time requirements for that. Quite often they're contested. It's an unsatisfactory quite often. So something you might want to think is amended termination provisions, for example, termination for convenience, but obviously that would have to be negotiated very carefully. But it's things to think about for giving people comfort in the event you can't get those performance guarantees. Sorry, so next slide, we're turning more to things to think about of those guarantees that you either have provided or been given already. Obviously, we're hoping that the economic impact of COVID-19 will not be as bad as everybody is saying, but just in case, it pays to have these things dusted off and checking in advance what you may need. So this is my checklist, and we're going to go through these in more detail, particularly the last three, by reference to case law later. First of all, an obvious one: when does my guarantee expire? Has it already expired? Obviously, if it has, you don't have any security, as it were. If it hasn't, when does it expire? Is it clear when it expires? So practical completion, end of the defects liability period. Is there a fixed date provided for, a backstop date perhaps? Sometimes parent company guarantees, you see it where it's just relating to the limitation period in the underlying construction contract. Sometimes equally there can be a debate about when it expires. So it's thinking through all these things in advance and making sure you know what your position is and you're confident on it. You then need to diarise that date, and if you think you might be making a demand on that guarantee, working out your timetable that will allow you to do that, and we'll go through this later in Uanda multiplex, in good time without having to worry about you're going to miss the boat in a panic at the end. So it's just thinking about your strategy. Equally, if you want to block a call, you might need to do things slightly differently as well. How much does my guarantee cover? Should be obvious. For example, does it reduce on practical completion? So again, just check that. So in terms of the next question, has the guarantor got any assets? Well, obviously, if they don't, your guarantee is not worth anything. With an established insurer or bondsman, the value should be as shown on the tin. Guarantees by others, that cannot be the case. So parent company guarantees, Carillion is a reminder that even very, very large companies can go under in fairly quickly, and suddenly the security you thought was worth a lot, parent company guarantee, essentially becomes worthless overnight. But it may not be as obvious. You may need to carry out accounting checks. What is that company now worth? Specifically, if it was offered if it was given a long time ago, has anything changed? Keep an eye on it. Do regular checks. Jurisdiction. I've had one where you've had an offshore parent company, and it's hard to work out what assets they have, because perhaps the accounting thing is not as strict there. It's very opaque. It's hard to work out what's gone on. Equally, enforcing a judgment, maybe even if it's obtained in the English courts, may take time. So things to think about there. Notification provisions. COVID-19, we have a lot of empty offices. Is there anybody home? This is something to think about. I mean, even on the on-demand case for NIGCO, we had, retrospectively, it's quite fun looking back at it, but we had to get a process server, drive up from Gibraltar and throw a demand over a fence of a well-known bank halfway in the middle of Spain, take a picture and sign a witness statement to say you'll serve, because they simply would not accept service by a courier. So it's thinking these things through in advance. Hopefully you won't have somebody that determined not to accept service, but if you're up against an expiry date, it's worth thinking about. Notification method. Can I get a hard copy there? Hopefully now lockdown's easing, it's probably not a problem, but it might be. How long will it take? Leave longer. Give yourself a buffer, safety buffer. Could you agree another method of service? I noticed in the Uanda and Multiplex case, the bank was very sensible. They said, yes, serve on us in England, that's fine. I think that was the court proceeding. It was the same principle. You know, hopefully people will act sensibly, don't rely on it. Ensure that you can notify a claim before expiry. Again, Uanda versus Multiplex, you needed an adjudicated decision before it expired in April, and it was going to be rendered before then but make sure you've left enough time. So how long until I get paid? Now, this is a key difference to on-demand bonds. On-demand bonds, as Anneliese explained, they should pay out pretty much instantaneously. With guarantees, they need to be established and ascertained under the underlying contract, and that can take time. ABI model form of guarantee bond is very commonly used, sometimes with bespoke amendments, in the domestic market, certainly. ABI standing for the Association of British Insurers, and you can read the clause there. The guarantor guarantees to the employer that in the event of a breach of contract by the contractor, the guarantor shall, subject to the provisions of this guarantee bond, satisfy and discharge the damages sustained by the employer as established and ascertained pursuant to and in accordance with the provisions of or by reference to the contract. The bottom line is that payment is unlikely to be made instantly, so you have to think about this in advance. So just some recent case law we're going to quickly run through before wrapping up. So Uanda versus Multiplex is a very recent case, and I think it's very helpful in terms of explaining how these guarantees work, or the ABI model ones, which are very common. So JCT Design and Build 2011 subcontract with bespoke amendments, and there was a dispute between the contractor and the subcontractor about extension of time entitlement and either LDs or loss of expense, depending on who won that argument. An adjudication was commenced by a contractor against the subcontractor on the 2nd of December 2019. A second demand for payment, we don't know quite what happened to the first, was made on the 17th of January 2020. And the bond expired on 4th of April 2020, and it was confirmed that that was a drop dead date. If you missed it and your claim wasn't in the right form by then, too late. The bond itself, and they called it a guarantee, was an ABA model form with a few bespoke amendments, but clause 1 was along the lines of the standard wording I read out. So the judge, first of all, he confirmed again, and there's a whole run of case law on this, but it's surprising how many times it comes up, that the ABI model form of guarantee bond is not on unless you make it, but generally it's not an on-demand instrument. Also, you have to look at the underlying contract, as the clause says, to see whether the amounts you're claiming have been established or ascertained. Now, a mere statement that money is due to the contractor is not enough, and that's in contrast to the on-demand situation. Here there was no certification procedure using a third party. under the underlying contract. So a mere demand wasn't enough, but a decision by the adjudicator awarding sums to the contractor, and this is what the judge said, would undoubtedly qualify as being an amount established and ascertained pursuant to the contract. And that was because it's temporarily binding on the parties. And Mr. Justice Rader basically said that if there was an adjudicated decision, the subcontractor would have to pay out, assuming it was a favourable decision to the contractor, and therefore so should the guarantee. And luckily, that adjudication decision was due before the bond expired, but it could not have been. So it's something to think about very carefully in terms of timing, especially if you have a hard stop. So just looking quickly at insolvency, COVID-19 in mind, we all hope that this won't be as much of an issue as we think it will be. Mr. Justice Coulson in Ziggurat versus CC International Insurance Company. Ziggurat employed County under a JCT 2011 form construction contract, and County provided an ABI form of performance bond, and again we mean guarantee, with a bespoke amendment for insolvency. This is quite often thought by people to be necessary as a result of a case called Peral, which I'll very briefly touch on in a minute. It isn't, but this sort of judgment confirmed that. County went insolvent and others finished their works. And the question was, when can I get my money? When can I get my cash? And it was held that the financial ascertainment of losses pursuant to the termination provisions had to be carried out. And anybody who knows about the JCT provisions knows that these takes a while, but you have to wait until after the work's complete. So there wasn't any liability until that had happened. And he also confirmed that then the bondsman would have the same defences as County would in having those and challenge those amounts. So you're facing a battle and a length of time before you can get your money, essentially. So finally, just a quick word on the Peral case. The JCT wording and the ABI bond is wide enough to include insolvency events without bespoke amendments being required. There's a 1994 case that causes some confusion on that, but essentially the breach of contract you're claiming against is the failure to pay a debt post-insolvency. In the Peral claim case, they hadn't claimed payment, they just said there's been insolvency. And the judge said, had a claim been made as the contract envisaged, it may well be that these proceedings would have been avoided, as plainly any consequent failure by the contractor to pay any such demand, if properly made, would have enabled a claim to be made under the bond. So it's just worth, when you're negotiating things, just have this in mind. So ultimately, in terms of cash flow, your ascertainment under the termination provision, certainly under JCT, is going to take a while. It's going to delay payments. One thing you could potentially consider is making amendments to the construction contract and the ABI bond to allow payments on account after insolvency. It's complicated drafting. It may add more to the cost of the bond, but it's something, you know, if you're very worried about it, it's something to think about, and it may become more common in the future. So with that in mind, I will hand back to Tony.
Thank you very much, Claire. Thank you very much, Anneliese. Covered a lot of ground in a short period of time. We've had a number of questions submitted, but before I come on to those that I've been copiously scribbling down, Anneliese, can I just ask you about distinction in approach between commercial courts and the TCC? So presumably, if you're acting for a party that's seeking to claim under a bond, you'd be better off in the commercial court, whereas if you're looking to restrain a court, you'd be better off in the TCC.
Yes, that's absolutely right, Tony. It's a very important distinction. The commercial court is based on sort of banking law that's very strict, and they're very much, you know, this is the lifeblood of commerce, is a term often used. Yeah. And we could see that in our case. So because we were calling on the bond, we decided to go in the commercial court. I should say, when we went to the Court of Appeal, they didn't quite know what the FIDIC contract was, which was interesting, but it didn't matter because the underlying contract wasn't really relevant for these purposes. But the TCC, I think, has shown more flexibility, and it perhaps is a bit more of a merits court, as we can see from the latter decisions that I was talking about. And I suspect they may have more sympathy. Whether that will be upheld on appeal, the 4 decisions that I talked about at the end, none of them were appealed. So there is that. But certainly you are definitely more likely, if you're a contractor or a bank trying to resist it being called on, you should go to the TCC.
So you think you might have got different results in those cases if they'd been in the commercial court?
I do, yes, I do. The middle two cases. I mean, the Ramsey decision per Mr. Lisa and the Jeremy Stuart Smith one, the last one, the MW Tech, they're quite critical actually of the other two decisions, and they actually say the last one says that, you know, those other two decisions are actually wrong. So there is a real mixed bag, and I think again it's very, very important to look at the facts and see if you've got strong facts that might be enough to persuade a TCC judge to follow the other two decisions. So
going forward, watch this space, I suppose.
Yeah. Yes.
Can I just moving on? We've had a lot of questions. Claire, you mentioned the sort of market impact of COVID-19, and you said you've been speaking to bondsmen. What's the feel about generally now cost of bonds and the implications commercially of COVID-19?
Well, when I was speaking to the surety providers yesterday, they wanted to emphasise it's still very much down to the individual company's financial risk. So a bond price could be anything from a 1% of the bond value over a year to 8% at the other end of the spectrum. For a new client, they said it's probably another 0.5% maybe on the costs. For people with more established relationships with them, that's not feeding through at the moment, but as I said, they are taking a lot more care with their financial information that they're requesting.
Yeah, it's quite an unattractive position for a bondsman though to ramp their prices up at this stage when the construction industry needs support.
No, I know, and I think they're conscious of that very much when I was speaking to them. I think the problem from their perspective is obviously they've got to price the risk in. At the moment, as I said, they're managing that risk by asking very specific questions and pricing it up front. But we'll have to see what happens. I think it's a watch this space because there's a bit of a hangover happening. We'll have to see what happens.
Okay. I had a question about adjudicators' decisions. So where you are the beneficiary of a adjudicator's decision in your favour, do you think you could go straight to call under a performance bond, and what do you think the position would be under a guaranteed bond?
Anneliese, do you want to go first for yours?
Yeah. Well, so under a performance bond, it doesn't matter as long as you've got an honest belief that you're owed some money. So yeah, whether you have a favourable or an unfavourable decision is irrelevant. It's about the honesty of your belief.
Yeah, so, with the guarantee it would be different. You'd have to have a favourable decision, and that's the Joanda multiplex case.
So just pausing there, if you've got an unfavourable adjudicator's decision, but you still have a genuine belief that your claim is good, and therefore the adjudicator's decision is wrong, you don't see a difficulty in calling under an on-demand bond.
No, you should be able to call on it, unless you've done something very stupid like written a letter saying I don't think I have any claim, but that doesn't happen very often. But yeah, as long as you have an honest belief, and it's an honest belief, it's not a reasonable belief, you're entitled to make that claim on the bond. That's what it's there for.
Okay. Just conscious of time, so one more question. COVID-19 and the impact that it's going to have on contractors' performance of their contracts, impact on their progress, etc., etc. Do you see any scope for any sympathy from the courts in terms of parties calling under bonds where a contractor's performance has been significantly hindered by COVID-19, but not necessarily to the extent that it entitles them to extensions of time, etc., etc.?
I mean, in relation to on-demand bonds, no, not unless the law's changed. It's very interesting to contrast it with Singapore, where obviously not only do they have unconscionability, but they've actually passed a law saying that for 3 months all LDs are cancelled in construction contracts. They've actually intervened through the state, whereas we've obviously taken a different approach. And I think the English courts are conscious that these bonds, their laws are attractive, so they want to keep commercial certainty. There may also be something to be said for keeping that, to ensure that projects get off the ground, because employers may not be willing to start projects without having performance bonds, particularly in a post-COVID. So although it seems counterintuitive, it may actually help the industry to have these and therefore be able to get projects off the ground.
Yeah.
Okay.
And with performance guarantees, obviously you've got the same defences as a guarantor as you'd have under the underlying construction contract. So you just have to look at the underlying position as you would normally in any claim.
Yeah. Okay, Claire, Anneliese, thank you very much. I think that's all we've got time for. Just to confirm that today's slides and the recording of the webinar will be available on our website shortly. Next week, we've got the 5th in our series of these regular webinars. Starts at 12 o'clock next Thursday, 11th of June. Jeremy Glover will be chairing the session. He's joined by Lynn McCafferty of 4 Pump Court, George Tatt of Secretariat International, and they'll be discussing claim preparation, good practice for claim preparation, and in particular thinking about some considerations in terms of COVID-19 notices. Details of registration will be on our website or will be forwarded in an email to be dispatched shortly. So thank you very much for listening today, and hopefully you can join us next week.